the court, Justice of the Court, appear for the applicant, Famous Ideas, together with my learned friends, Mr. Homo and Mr. Vabaza, on the instructions of Malulachi and Co.
Thank you very much, Advocate Chikila.
May it please you, Justices, Deputy Justice, Chief Justice, I appear together with Mr. Scarborough for the first, second, and third respondents, also known as GEMS.
Thank you, Mr. Bava.
May it please the Court, Deputy Chief Justice and Justices, surname is Kromhout. I appear for the fourth and fifth respondents together with Mr. Wessels.
Thank you, Mr. Kromhout. Mr. Chikila.
Thank you, Deputy Chief Justice. I believe my mic is on, at least at this stage. Thank you. Deputy Chief Justice and Justice of the Court, I propose to set out just briefly the outline of the applicant's arguments in various topics. I do hope to get through all of them before the allotted time. The first issue that we propose to deal with is the application for leave to appeal. The second issue is the obligations of the first to fourth respondents, GEMS. The GEMS parties, I'll refer to them as such, to disclose the Rule 53 record. The third issue is what we say is the true nature of the tender process that is the subject of these proceedings. The fourth issue that we propose to deal with is the nature of the powers we say were exercised by GEMS, or the function performed by GEMS in respect of the impugned decisions. The fifth issue, we would want to address the court on what we understand to be the import of the latest judgment of this court in Swanepoel, insofar as we believe it relates to the present matter. The sixth issue, we would want to address the court on the common law grounds which are relied upon by the applicant in the alternative to the public law grounds of review. And the last issue I would like to deal with is the replying affidavit in the application for leave to appeal. Deputy Chief Justice and Justices of the Court, I propose in respect of the first issue, which is the application for leave to appeal, to refer the court, and I do not wish to detain the court on this issue. I would propose to refer the court to the applicant's first written submissions in paragraphs 29 to 47, where we set out on behalf of the applicant why we believe, firstly, that this matter engages this court's jurisdiction, firstly, in the sense that it raises a constitutional issue, and secondly, the interests of justice we submit favor that the matter be heard by this court. We do also deal there in paragraphs 29 to 47 with the last aspect that in any event, the matter raises an arguable point of law. And I will address the court on this essence of the issues on that aspect. We will conclude by submitting that application for leave to appeal ought to be granted. We will demonstrate that there are prospects of success in the appeal, an issue that I'll deal with, unfortunately, substantively on the merits. But before I deal with the substance of the matter, could I refer the court to GEMS heads of argument, the supplementary heads of argument, just as a preamble to the submissions that we will be making on behalf of the applicant. I'd like to refer the court to paragraph 43 of GEMS supplementary heads of supplementary submissions. In paragraph 43, GEMS says the following: moreover, it is submitted that nothing turns on the alleged non-compliance with discretionary private tender process and or bidding conditions. GEMS was entitled to take the impugned decision to appoint a particular service provider and reject the applicant's bid or offer irrespective of any bidding or tender process or conditions, since GEMS was neither obliged in terms of the law be it the MSA, the reference to the MSA being the Medical Schemes Act, or its registered rules or otherwise, to follow any tender process or tender or procurement process in the first place. Over the page at paragraph 44, GEMS says the following: calling of a bidding process, even if provided for in terms of a procurement policy, was simply discretionary because there is no legislative provision governing the appointment of service providers. In essence, Deputy Chief Justice and Justice of the Court, GEMS says at paragraphs 44, 43, 44, and 45, we can do anything we want to do with the tenders that were submitted. We can reject the tenders irrespective of what we undertook to do in the bid conditions, and you have package and deliver chronic medicines to GEMS members in various locations within the country and outside of the country's borders. Of 1965. At clause 3.1.2, the service providers contracted by GEMS are required to perform the services in accordance with the standards used by the Pharmacy Council to accredit pharmacies in terms of Section 22 of the Pharmacy Act. I refer to those provisions of the bid conditions because one of the complaints raised by the applicant in the review application is that the successful tenderer did not meet these requirements, some of which are statutory requirements, some of which attract a criminal sanction under the Pharmacy Act. That is one of the grounds upon which the applicant relies in the review application to challenge the decision by GEMS to award the tender to the successful tenderer, in this instance, the fifth respondent. Could I then refer this court to what was said in MTO Forestry? MTO Forestry is a judgment we have referred to in our supplementary written submissions at paragraph 37. We quote in particular a portion of the majority judgment in MTO Forestry, but I would like to refer to certain portions of that particular judgment itself, and not only what is set out in paragraph 37 of our written submissions. Deputy Chief Justice, Justice of the Court, at paragraph 35, the majority in MTO Forestry said the following in a slightly different context, and I'm saying it's a slightly different context, but nothing turns on this because I'm going to demonstrate that that ought to apply as a matter of law to the impugned tender as well. At paragraph 35 of MTO Forestry, the SCA says the following. As pointed out by our colleague, Justice Tambuza had written the main judgment in that matter. Justice Nafsa and Justice Davis was acting at the time, were the authors of this portion of the judgment. As pointed out by our colleagues, this court in Loughborough was astute to recognize under the circumstances of that case, notwithstanding a contractual right of a provincial government to withdraw a tender, the relationship between the public authority and the private tendering entity was governed by principles of administrative law. There, I just want to that decides, or rather considers first, and decides which tenderer to accept, which tender rather to accept, and which tender to reject. It's significant for present purposes because the suggestion by our learned friends for GEMS and the fourth and fifth respondents is that all that occurred here during the tender process was an exercise of a contractual right proper. That is, on the assumption we think that there is an equality of arms. The second aspect that we want to emphasize arising out of MTO Forestry is that the court must necessarily have regard to the circumstances regulating a resolution of disputes arising out of the tender process. That is important because because GEMS relies primarily on the decision of the SCA in Public Protector. I will address the merits of that decision so far as it is suggested that they apply in the present matter in due course. But what we suggest ought to be extracted from the Public Protector decision is that the court recognized that there is an alternative remedy, or rather there is a remedy under the MSA, under the Medical Schemes Act, in terms of which an aggrieved member of GEMS could ventilate whatever issues they have with GEMS decisions. On the approach adopted by GEMS in these proceedings, the applicant simply has no remedy at all. We say that can't be. It can't be that a party who complains that there wasn't a fair adjudication of its tender in circumstances where GEMS itself elected to call for tenders on the basis of certain agreed terms, can now come to court and say, forget about what I told you, you have no remedy. The concept of equality of arms is a concept that has been recognized by this court. And I would like to refer to a judgment of this court in S versus S and another. It's a judgment that is not referred to in our written submissions, Deputy Chief Justice. But we have, as I understand it, we have conveyed our intention to refer to this judgment to our learned friends. It's S versus S and another. It's a 2019, it's recorded rather as 2019 volume 6, SA1. It's a judgment of this court. At paragraph 40 of that judgment, by a unanimous decision, this court said the following: equality of arms has been explained as an inherent element of due process of law in both civil and criminal proceedings. At the core of the concept is that both parties in a specific matter should be treated in a manner that ensures that they are procedurally equal, they are in a procedurally equal position to make their case. In particular, weaker litigants have an opportunity to present their case under conditions of equality. Then at paragraph 41, the equality of arms principle ensures that in a particular dispute, that parties in a particular dispute receive an equal opportunity. I mention this, Deputy Chief Justice and Justices of the Court, because in the bid conditions, there was an enacted fair procedure, and that is set out in great detail, and perhaps I should only refer this court to volume 1 at page 70 of the bid conditions. At clause 1, the bid conditions provide as follows: all role players, which is a defined term, involved in the procurement process shall conduct business and themselves professionally, fairly, reasonably, and with integrity, and shall disclose all interests of any nature, and shall report all breaches as required. I think that's what his intention. The definition of role players is a wide definition, as the court will see at clause 8. It includes GEMS role players themselves. So GEMS itself bound itself to act professionally, fairly, reasonably, and with integrity. The definition, as I intimated earlier, the definition of a role player appears at page 73 at the foot of that page. But as I submitted, it includes GEMS. So GEMS undertook to act in a particular way, including fairness. We say, on the approach that GEMS has adopted now, that the applicant has no remedy at all, who should decide, or who can decide, whether the principles set out in the bid conditions, which as we submit must be understood against the concept of, or rather the fact in this case as we submit, that there was no equality of arms, who should adjudicate the question as to whether the bid conditions were adhered to? It cannot be, we submit, that there is no remedy at all. We have identified, or rather the applicant assets 3 remedies in the alternative. The first one is the applicant contends that the decision by GEMS, the impugned decisions in particular, are reviewable under PAJA. The alternative is that they are reviewable under the principle of legality, with the last alternative being that they are reviewable at common law. The position, we say, must be that they are reviewable one way or the other. The first issue that arose is motion when the review application was instituted, which is that you must disclose a record. I, as the applicant, have identified 3 grounds of reviews. Deputy Chief Justice and Justice of the Court, I don't intend to take the court through all of those. The founding affidavit is relatively short, but they are captured from paragraph, at least from paragraph 68 of the founding affidavit at page 39 of volume 1, all the way to paragraph 106, I beg your pardon, at page 58. Those grounds in sum set out what the applicant contends are the basis upon which the decisions are reviewable under PAJA, or under the principle of legality, or under the common law, and the facts are set out there. The applicant's position is that on those facts, and on that pleaded case already in the founding affidavit, GEMS ought to have been compelled to disclose the Rule 53 record. The reason is we rely on the decision of this court in Competition Commission. In that decision, I accept, Deputy Chief Justice, that it's a decision that is very well traversed in the papers by the parties, and this court would have considered it. But I just want to emphasize certain aspects of that decision. At paragraph 119 of that decision, this court said, the court chosen, and I'm reading from the middle of paragraph 119, the court chosen by an applicant in a review application must be able to assert its jurisdiction on the basis of the founding papers. Where no facts are alleged in the founding papers upon which jurisdiction could be founded, the applicant is not entitled to the production of the record in the hope that it will clothe the court with the necessary jurisdiction. That's paragraph 119. At paragraph 120, the court says there, and I simply want to paraphrase it, the court says there that it doesn't matter how bad the grounds of review, that's the merits of the review as we understand that passage, it doesn't matter how bad the merits of review are. If the court in which the applicant has instituted the proceedings has jurisdiction, or could in the founding papers establish jurisdiction, the decision maker ought to be compelled to disclose a Rule 53 record. In this particular matter, there is no doubt that on any of the pleaded grounds under PAJA, legality, and common law, the High Court in Pretoria clearly had jurisdiction, at the very least territorial jurisdiction. Under PAJA, the applicant itself, the applicant's pace of business itself could found jurisdiction of the High Court in Pretoria. Under common law, of course, read with section 21 of the Superior Courts Act, again, we submit that the High Court clearly had jurisdiction. In those circumstances, we submit that GEMS ought to have been compelled and should be compelled to disclose the Rule 53 record. The rest of the issues that have been raised could have, we will address them, but they could have been addressed in the merits of the review application with the fullness of the record and the issues having been traversed by the parties. But what then occurred is, as at volume 2 of the papers, page 106, GEMS files a Rule 65D3 notice. In that notice, GEMS presents an issue that it contends should be decided. In sum, at paragraph 1 of that notice, GEMS contended that its decisions, or rather it asked of the court to decide whether its decisions are reviewable in terms of PAJA, alternatively legality, further alternatively the common law. And it contended there that its decisions are not reviewable. Over the page at page 107, paragraph 3, GEMS contended that this issue that it has presented under the Rule 65D3 will be dispositive of the application. It was in that context that the matter ran in the High Court. There is a lot that is said, Deputy Chief Justice and Justice of the Court, about what the practice note and what the manner in which the matter was conducted in the High Court. We have to address that in a very short way. The joint practice note that is relied upon by the respondents, it appears in volume 3 at page 265. But the relevant portion that I would like to refer the court to appears at page 266. Under paragraph 6 of the joint practice note, it is stated there by the parties, all three of them, in the last paragraph, in the last sentence rather of paragraph 6.1, that the review is sought in terms of PAJA, alternatively the principle of legality, and further alternatively in terms of the common law. Then over the page at page 267, the following is recorded at paragraph 6.7. In these proceedings, the court is asked to decide 6.7.1, GEMS notice in terms of Rule 65D, and then it says, GEMS contends that this application be argued first, as the outcome of this application will be and then 6.7.2, the applicant's application in terms of Rule 30A to compel was also the second issue that is set out there for determination. Then at page 270 of the record, paragraph 11 of the joint practice note, the parties set out the issues that require determination, and GEMS for the first time in this instance says, 11.1, whether a review application can be brought against GEMS in these circumstances. GEMS contends that this is a jurisdictional point to be determined upfront. And then the next sentence, the applicant does not agree with GEMS' contention in this regard and contends that the alleged jurisdictional fact, in fact, a defense to the merits of the review. That's what the applicant said. And then at paragraph 11.3 of the same page, at page 271, whether GEMS is obliged to provide the rule record in circumstances where GEMS contends that this is a jurisdictional fact of the review proceedings against it, and that it is not present. Then the following recordal is made. The applicant disputes the alleged jurisdiction, contends that GEMS is not entitled to refuse to disclose the record. Then in the judgment itself, the judgment appears at volume 4. Just want to briefly deal with how the court then dealt with these issues, the High Court. At page 209 of the record, volume 4, paragraph 7 of the High Court judgment, the court says the following: before this court, bracket, in this interlocutory application, then the court under the next head deals with the Rule 65D issue. The entirety of the judgment, and the court can read it for itself, the entirety of the judgment, the court will see that the entirety of that judgment dealt with the Rule 65D issue. The High Court then dismissed the main application. We to this court. That is simply factually not correct with respect. The court adopted a particular approach. We are here because we disagree with the approach that was adopted by the court. We say that the court ought to have decided the GEMS obligation to disclose the Rule 53 record and ordered GEMS to do so. The rest of the issues could have and should have been decided in due course. The what has since occurred, and the court will be aware of this, is that a similar matter has since served before the same division. A full court in Polmed, in the matter of Polmed, which the court has been addressed in the written submission, has now found that the
that. Because as I read the judgment of the High Court seemed to suggest that you don't say much under common law grounds. But the founding affidavit and the practice note suggests clearly that the review is brought on all three legs.
Yes.
And maybe the question was bedeviled by your view on the interior question.
Yes.
Because you said to the High Court, it's not necessary to deal with Paja legality, because we come in even on the common law.
Common law. Yes.
And that may have compounded the problem in the High Court, seeing that that was an argument that rested exclusively on the common law. But rather you were saying, we don't have to convince you on any of these bases. And I don't agree with you on that, by the way. But that's what was how the interior question and, in a sense, the suggestion that you relied exclusively on the common law may have got confused, and you must take some responsibility for that.
I am happy to do so, Justice Colapan, but can I qualify it with this? When the High Court actually decided the matter, it relied on the decision in Public Protector. That decision was a decision on the exercise of public power. So if the question was limited to the common law review, it seems to us that the Public Protector decision would not have been of relevance. Thank you.
Lastly, from my side, you argue that GEMS exercises public power.
Yes.
And in your supplementary submissions, you located those arguments in different provisions of the Constitution that you haven't relied on previously, but they still revolve around the same argument. I want to establish whether it is your argument that whenever GEMS acts, they will be involved in the exercise of public power, or whether that's a question that we need to address at all, but rather whether we simply need to address the limited question of whether GEMS' decision in this matter constitutes an exercise of public power, because the answer might be different.
It's the latter, Justice Colapan. Attractive as it may be to suggest that it's the former, in light of the judgment in Swanepoel, but our case is limited in this instance to the circumstances of this particular matter, where there is a call for tenders, and we set out the reasons why that is the case. So the court may want to decide the bigger issue, but we think that it is not necessary to do so.
And sorry, just lastly, and I know I did say lastly, but you've, in your argument, indicated how the procurement decision in this matter relates to the provision of healthcare services and not just courier services.
Yes.
And it would seem that the requirement of having a qualified pharmacist may lend itself to the conclusion that it is healthcare services. You don't rely on the right to healthcare, do you?
As applicant, no, we don't. We say someone else has that right, and this is the process through which that right is fulfilled. No.
Okay, thank you.
Thank you, Justice Colapan.
Yes, it's just following on that, you rely on this court's recent decision in Swanepoel, the Profmed case. Now, Profmed seems to me to be distinguishable, and tell me if I'm wrong, on at least two bases. The first is that in Profmed, what had happened was that the members, the Profmed had terminated the members' medical aid and deprived them of, in essence, as a consequence of effective medical treatment. Now, that seems to me to impact directly on the right to access to healthcare in Section 27. Do you accept that?
I do, Justice Majid.
How does this impact that right? Isn't this a private contract between bidders, dispute between bidders?
We say it's not, Justice Majid, for the reasons I narrated earlier. The reason is this. A private contract, in the true sense, presupposes that the parties exercise their rights at an equal footing. That you could have someone who decides behind closed doors in circumstances where only that someone knows what is going on doesn't seem to us to fit in perfectly within the concept of a private law right that is exercisable in that sense. And that's why...
To interrupt you, so accepting that as correct, what constitutional right is impacted? I'm trying to locate constitutional jurisdiction in this case.
Justice Majid, I apologize. Justice Majid, the constitutional issue I had indicated earlier, that if we have a reviewable right, then under any one of the three grounds that we have identified, that the applicant has identified, then at the very least we're entitled to a Rule 52 record. If the finding of the court is eventually that you can't come right under public law, padra or legality, we say that at common law, the decision is in any event reviewable. That's because the fairness procedure that is enacted in the bid conditions itself imports a requirement that someone must interrogate the decision itself. James says we have...
Sorry, Mr. Chidika, I'm still trying to locate what constitutional right is impacted. You say it's the right of access to court.
Yes.
2034.
Yes.
But you've had a hearing.
We haven't had a hearing on, Justice Majid, we haven't had a hearing at all on the question of whether the rejection of our bid was lawful. There's been no such hearing at all.
The other basis, I said there are two bases as I can see them. The second basis why I think prima facie to me, Prof. made the Swanepoel Nominee case is distinguishable, is because there the decision was taken by appeal bodies created under statute, you know, the board,
Yes.
under the MSA, under the Medical Schemes Act. But it's not the same here, is it?
It's not the same, Justice Majid, but there is an aspect that is the same. And our learned friend suggests that it's orbital. But at paragraph 50 and 51 of this court's judgment, this court says the following: the cause of action for review must be transmissible, whereas in the case here, the estate has a financial interest. Then the court refers to Mkhize. And then at 51, this court says, this raises a question whether a decision of a medical scheme or any entity of that medical scheme constitutes administrative action as defined in PAJA. The question, as we read that sentence at least, and I'll come back to the import of it, as we read that sentence, that is not limited to a decision of an appellate structure under the MSA rules, under the Medical Schemes Act. And then the court says the following: if the administrative action for reasons given earlier, if it is administrative action for reasons given earlier, this may not render it transmissible. And then at paragraph 52, the court says this question was answered in the negative in Pennington. Justice Majid, we read Pennington, says the facts in Pennington are similar to what we say were the facts here. There was no appellate structure. There was no exercise of a power, even on the approach that Justice Majid has suggested to me now, by an appellate structure. It was a decision by a medical scheme proper, or rather by an entity akin to a medical scheme proper. And this court says, it seems to me that Pennington was not correctly decided. That raises a number of issues, and that's why I'm saying it's relevant to this issue. If Pennington wasn't correctly decided, or the view of this court is that Pennington was not correctly decided, then it goes to the heart of the basis of the decision of the SCA in the public protector matter. That's because the SCA in that judgment relied on the Pennington judgment as well in the High Court. So if the position is that that judgment in Pennington wasn't correctly decided, we submit that in this case we presented a case that fits in perfectly, we say, with the circumstances that detained Pennington, and for that reason, we would believe that the court, if the court is of the view that Pennington wasn't correctly decided, then it should ratify it here.
Tikila, I must tell you that in all fairness, even after all what you've said, it just still seems to me to be a contract, private contract here between bidders, unsuccessful bidder coming to court. But let's move on. Just the last aspect now, assuming that of working on the basis that we find jurisdiction for whatever reason, then there is the second question whether we should grant leave. Now that one of the aspects that we have to bear in mind there is whether it's in the interest of justice to hear this case. Isn't this matter moot? Hasn't this tender run its course?
No, that's the suggestion by our learned friend Justice Majid. The original contract period, as per the tender, was going to be 1 year. It was going to run from January 2023, renewable for 4 years. So the contract itself, and there's no suggestion, and that's why they don't say that the contract has come and gone. there's no suggestion on the papers that the contract has come and gone in light of the contractual right that GEMS would have had to extend the validity or the duration of the contract. So it seems to us that it is not moot. But Justice Majid, we've presented arguments on this. Even if it is moot, we sit on substantially similar facts in Polmed, with a matter that is probably on its way to this court, in circumstances where the full court of the High Court in Pretoria has found the other way and suggested that this judgment is incorrect, the judgment in this matter is incorrect. It seems to us that it is in the interest of justice in any event for this court to pronounce on these issues once and for all. So we would suggest that even if the court were of the view, we say it's not moot, but even if the court were of the view that the matter is moot, this is one of those circumstances where this court ought to decide this issue finally. There is a Murray judgment that is 3-2. There is a range of High Court judges which take a different issue. We've addressed those aspects, Justice Majid. I don't want to bore this court on those issues, but the submission we make is, firstly, it's not moot, and secondly, even if it is, this is perhaps the best instance to decide the issue once and for all.
I just want to understand, on the first ground, you say it's not moot because it's, the contract is renewable, or it was renewed?
Well, we say it was renewable and the services have not been reissued for tender, so it must mean that it was renewed.
How does the renewability of a contract establish that they will get the contract and you may not?
No,
Surely it's an option to renew, is it not?
it's an option, but that follows from what we say is an unlawful contract itself, from the underlying contract.
I must confess, I don't follow that, but thank you. Thank you, DCJ.
Thank you, Justice Majid.
Mr. Shikila, I want to explore an avenue that you discussed with Justice Collins. I can refer you to Rule 53.
Thank you, Justice Terron. Got it.
Yes. So it speaks to review.
Yes.
All proceedings to bring under review, this is what can be brought under review as I read the rule.
Yes.
The decision or proceedings of any inferior court and of any tribunal, board, or other body or other officer performing judicial, quasi-judicial, or administrative functions.
Yes.
So it's those decisions
Yes.
or proceedings
Yes.
that can be taken on review.
Yes.
So in a review, where it's not that the subject matter of the review falls within one of those categories,
Yes.
must a court not first determine the nature of the decision or proceedings
Yes.
to see if it falls under Rule 53? And that, isn't that the jurisdiction question or the jurisdictional fact that must be met before decision or proceedings can be taken on review?
Justice Terron, I don't think one can say the court must decide that issue in a vacuum. I'm to
So must the court first decide that question?
it
That,
must.
that this, the subject matter of the dispute, what is being brought to you, Rule 53. understand is made that the court was not presented with sufficient information to be able to make that decision.
Yes.
Isn't the ultimate test, no matter at which stage that decision is made by the court, whether this is a matter that falls within Rule 53, isn't the test whether sufficient information was placed before the court to make a proper decision? I would understand that objection. And that's not what I'm hearing the applicant objecting to.
No, it is, Justice Theron, because we say the court couldn't have made that decision at that time.
So what is the applicant saying? What information did the court not have before it when it made the decision? And what information, if it had been placed before the court, would have allowed the court to come to a different decision?
So, Justice Theron, in the heads of argument filed on behalf of the supplementary written submissions, I referred to paragraph 44, where James tells us that there is a procurement policy. That and its relevance to this, and the nature of the powers that James exercises wasn't before the court, but we know it exists. There may be more.
What is a procurement policy?
It's a policy, generally, Justice Theron, that regulates how an entity is to procure services.
And how would the procurement policy of an entity influence whether the decision is reviewable?
It would influence it at the very least under the common law, because the obligations that that entity has as between it and the tenderers may well be enacted in the procurement policy as well. I indicated, Justice Theron, that there may be more. We know that GEMS, in this instance, renders a particular service, we say, in pursuit of the government objectives. It may be that part of the in any contract, service level agreements or with the Department of Public Service Administration.
We're talking now, Mr. Shikila, about the contract between GEMS and the department.
Yes.
How does that impact on this matter?
It does, Justice Theron, in the sense that if those documents show that the power that is exercised is the public law power, one would be able to find that over and above what we have presented in the founding affidavit on the record itself.
Yes, but we know what the tender was for.
We know what the tender was for.
Yes.
What we don't know is under what regulatory regime the tender was issued. And that
Clear that I follow you, Mr. Shikila.
Sorry, Justice Theron, I'm saying that we know what the tender was for.
Yes.
What the tender was for is, in my submission, no answer to what the regulatory regime as between the Department of Public Service Administration and...
When you refer to regulatory regime, can you explain what are you referring to, please?
I'm referring to the original source of the power that GEMS exercises. GEMS tells us, and we refer to it in the founding affidavit, GEMS tells us that it has been mandated by government to do certain things. It sources the mandate from a policy and an approval. What else happened between the policy and the between the policy, the approval, and the issuing of the tender is something that the record could disclose.
I'm sorry, I'm a bit lost. GEMS is a medical scheme, yes.
That's correct.
And it was contracting couriers to deliver medications to its members.
Yes.
How does that relate to any regulatory scheme
It does.
with the state?
It does, Justice Theron. Can I take the court to volume 1 at pages 55 and 56? And just to identify what GEMS says of itself and its interaction with the state. It's pages 55 and 56, Justice Theron. At the top, it says at page 55, who are we? And then it sets out before that, below that, it sets out before GEMS. So we know that what is set out there is the mischief, so to speak, that was sought to be remedied by the registration or establishment of GEMS. One of those, it says in the last bullet under before GEMS, the government who contributes greatly to its employees' scheme payments had no opportunity to participate in the management of a medical scheme on which the public service employees are part. And then below that, it says introduction of GEMS. The beginning of GEMS was a historic moment when in 2002, the cabinet approved a policy framework on a restricted medical scheme. We know that that restricted medical scheme was GEMS, eventually became GEMS. Below, at the foot of that page, under the heading, government's commitment to an equitable and affordable medical scheme, GEMS tells us that the implementation of GEMS is a positive step that positions government as an employer of choice. That is, we say, we link that to the obligations of the state under Section 195 of the Constitution. Below that, in the last paragraph, on 3 November 2024, after careful consideration of the findings of a detailed feasibility study conducted that same year, Cabinet approved that the Department of Public Service continue to work on the first bullet is the registration. So we know that GEMS was established by the state. That's what GEMS tells us. Justice Teron wanted to say.
Now, what you've referred us to, Mr. Shikila, wouldn't that, just what you've referred us to in the middle of page 55, and that the government contributes to the scheme payments, wouldn't it make a stronger argument for the applicant that GEMS is a public entity or partly private, partly public entity? If, and that was going to be my next question, is there any funds in GEMS that's received from state monies, from the state coffers?
Our understanding is the answer is yes, Justice Teron. The problem, Justice Teron, and I understand the proposition. The only challenge that the applicant has.
It's a question.
I understand the question, Justice Teron, I apologize. The only challenge that the applicant has is it not risky for the applicant to say, that's my case, decide it on that. And that's why the applicant said it is preferable to get the Rule 52 record. And yeah.
A case must be decided on the facts.
I understand, Justice Teron.
Does the state contribute or partially contribute or subsidize the employee's pension, medical scheme?
Absolutely, yes.
Where does that appear in the papers?
That appears in that very same passage, Justice Teron. I was going to take you through those. In paragraph, at page 56, in the middle of page 56, implementing GEMS also provides a government with greater control over the money it currently contributes to the healthcare sector and also cover the selection and quality of healthcare benefits. Government is now able to directly influence GEMS.
If we can just stop there, please, Mr. Shikila. I'm not sure that what you've just read means that government subsidizes its employees. If you look at the first part of that sentence, it says, implementing GEMS provides government with greater control of the money it currently contributes to the private healthcare sector.
Yes.
We don't know what exactly that is referring to. We can't assume that that's referring to contributions to GEMS.
I accept that, Justice Teron.
And the next sentence, and also over the selection and quality of healthcare benefits to which its employees contribute. Now that is a choice of employees. Employees themselves are contributing. That is not money from the state subsidizing its employees. My question is whether it has been shown that the state subsidizes its employees in terms of healthcare, and whether the money, some of the money that GEMS is receiving is from the fiscus.
Yes. Justice Terron, just a moment, I apologize. Yes. My learned friend, Mr. Khomo, has referred me to paragraph 102.2, Justice Terron, at page 54. And perhaps I should have referred you there. The employer's contribution at paragraph 1022 is a contribution that is made by the state. The employer, by definition, under this regime, is the state. And the state contributes 75% of the total contribution payable to GEMS.
What is the significance of that?
I beg your pardon?
What is the significance of
The significance of that is that it shows that GEMS there are funds that flow from the state to GEMS. Those funds, we know, are traced originally from the PSA, the Public Service Act, read with its regulations that require of the state to provide for these contributions.
And what is the significance of that?
It is,
Where does it take us?
on that approach, it would show that GEMS exercises a public power, as we have said.
How do we draw the link? That's what I want to understand.
That's because, Justice Terron, the state funding mechanism, and we've traced it in sections 213, 214, and 216 of the Constitution, the state funding mechanism comes from the national fiscus.
And where is the authority for the proposition that if state funding comes from the fiscus and to an entity, then it makes that entity a public entity?
There is Justice Terron, there is a range of authorities.
Do you understand what I'm trying to, I'm trying to understand?
No, I understand what you are trying to understand, Justice Terron. I'm trying to make sure that you understand what I'm understanding. The proposition is that one can go back to the decisions of our courts from the SCA in Transnet, in Umfolozi, in Caliber Clinical, in All Pay 2, where the state, All Pay 2 perhaps not the best example, Justice Terron, where the state funds the machinery, where the state funds an entity like this, it would seem to us that it is clear that the decision, the state's affair, or rather GEMS in this case, is wound, I'm trying to find the right term, is wound in these affairs of the state in the true sense of the word.
Well, I would like to give you the opportunity in reply to look at those cases that you've referred us to and to say, on the basis of these cases, this is what it says, as a consequence of it receiving state funding, then it's either a public entity or exercising a public function.
I understand. I will do so, Justice Terron. Thank you.
I have a few more questions. Now, the respondents say that in the High Court, the issue relating to review was limited to common law review. What does the applicant say about that?
That's incorrect, Justice Terron, with respect, and that's the debate that...
In your answer, can you refer to the record in support of your answer?
The question before this court, Justice Terron,
I'm asking about the question before the High Court.
yes, the question before the High Court, I did, Justice Terron, at page 270 of the record.
Which volume is that, please?
It's volume 3, I apologize, Justice Terron.
Yes.
There, the question formulated by GEMS as a jurisdictional issue necessarily included the question of the exercise of public power. It was,
What are you referring to, please, Mr.
it's
Shikila?
paragraph 11, Justice Terron, I apologize. So the question itself that was referred by GEMS to court for determination, and which the court determined with reference to the public protector decision, was a question of the exercise of public power and not the private law or rather not the common law grounds of review. There was,
Where do we see that?
it's a, Justice Heron, let me take it step by step. In the Rule 65D notice at page 106, the question is formulated by GEMS, and it's formulated to include the exercise of public power.
That's at page?
106 of volume 2, Justice Heron. So the question itself necessarily included the question whether the decision is reviewable in terms of haja or the legality principle. That is the question that GEMS presented in its notice. When the court decided that issue,
Just a minute, Mr. Shikila.
yes,
This was in the notice that was filed in terms of Rule 65,
yes,
right?
yes,
Then there was a joint practice note that was filed.
yes.
Now, we all know about the papers, the pleadings. What was decided, what did the parties say to the High Court was the issue the High Court had to decide?
It is whether the decisions are reviewable under,
Where do we see that?
it's in paragraph 11, Justice Theron. At page, the paragraph 11 that I referred you to. At 270. At paragraph 11.1, whether a review can be brought against GEMS in the circumstances are those defined by the 65D3 notice, and they include public law. We disagreed with the approach, but that's what the court was asked by the parties to decide.
In the High Court judgment,
Yes.
does the High Court say that the question before it was limited to common law review?
No, it doesn't. It doesn't, Justice. In fact, it expressly refers to the Rule 65D notice, and I took the court to paragraph 8 of the judgment of the High Court at page 279.
Now, what arguments did the applicant advance in the High Court regarding PAJA and legality review?
The argument, Justice Heron, was that the decisions are reviewable under PAJA in the sense that we are contending now. Of course, the legal argument has been developed further in light of the decisions of this court. But the decision, it was exactly as pleaded in pages 55 and 56 of the founding affidavit. And that was the only set of papers that was before the court for purpose of the Rule 65D3.
Yes, thank you, Mr. Chikila.
Thank you, Justice Heron.
Thank you, Deputy Chief Justice.
Thank you, DCJ. Mr. Chikila,
Yes, Justice.
the portions that you read about the establishment of GEMS by the government did that as the employer, not so?
As the employer, as between it and its employees, yes.
Yes, for the benefit of its employees.
Indeed, yes.
It then created a closed medical aid scheme, like any other employer would, I suppose.
Not necessarily, because the power of, the source of the power of government to do that wasn't like any other person's power. It is a power that is sourced directly from, we say sections 195 of the Constitution, but through the Public Service Act. So the power of the source itself located in public law.
So regardless of whether the government does it as an employer,
Yes.
that's
It's irrelevant.
irrelevant.
Yes, we say that.
Thank you.
Thank you.
Thank you, DCJ.
Mr. Chikila, that appears to be the questions for you.
Thank you, Justice. Thank you, Deputy Chief Justice, and thank you, Justice Oga.
And I think it's an opportune time for the court to take the 15-minute adjournment.
Scott, please. It was much more than simply the state being the majority shareholder or the
The only shareholder.
the only shareholder.
Yes.
But the point we are making is that in that paragraph, it is clear also that the involvement of the state and the public funds was a consideration. So it wasn't limited only to that aspect.
Thank you, DCJ.
Chikila,
Yes, Justice.
What is your response to my struggle bookkeeping question to Advocate Bava?
Justice Matopo, I think it's a, with the greatest of respect, I think it's a formalistic approach to what in fact occurred. What in fact occurred, and that's why I started with the example of what occurred in Goodman. The state itself has its own obligations to its employees. It undertakes to make contributions to its employees in the form of a portion of the medical aid component. It then contracts, I'm saying contracts, it then engages GEMS to perform that very function. I don't think, unless I misunderstood Justice Matopo your question, I don't think that that distinction matters, or it's a distinction of substance on the issues that are currently before the court.
Mr. Chikila, in the High Court, this case was really about whether you were entitled at that stage of the proceedings to compel production of a Rule 53 record. Is that correct?
At this stage of the interlocutory application, yes, Justice Rogers.
Do you accept that in order to compel production of a Rule 53 record, you must bring yourself within the scope of the rule that entitles you to the record?
I accept that, yes.
So you had to establish that the decision to award this tender was a decision by a inferior court or tribunal, board or officer performing judicial, quasi-judicial or administrative functions.
Yes.
Doesn't that really dispose of the issue you argued in your first set of submissions, which was that the court shouldn't have gone into that, it should first have compelled production of the record?
Well, that was our approach, Justice Rogers, except that the parties agreed that the bigger issue, I'm saying the broader issue itself was to be decided. And that issue is the issue that was brought in the Rule 65D notice. So it was much more than what was initially contemplated in the Rule 30A application.
But even whatever the parties contemplated, if you were seeking to compel the obligation that is set out in Rule 53(1)(b),
yes,
you needed to show that the decision that you were purporting to review, yes, fell within the scope of Rule 53(1).
I understand that, yes.
Which means that before the court could compel GEMS to produce a record, it needed to be satisfied that the decision that you were purporting to have reviewed was of that category.
That is correct, yes.
So the High Court was certainly correct and entitled, just on the ordinary reading of 53, to investigate that question.
I would accept that, Justice Rogers, except that we said the question as formulated wasn't one that invokes the question that you've just postulated to me now.
Well, I would have thought that since typically the matters which fall within the scope of Rule 53(1) are the exercise of public powers under statute, that would have been what had to be investigated. In either way, what had to be investigated was whether the decision could be brought under review.
Indeed.
In terms of Rule 53. And you say, well, you could bring it under Rule 53 if it was a PADGER case, if it was a legality case, or if it was a common law case.
Yes.
But either way, you had to make that contention good before the judge could come to your aid and compel GEMS to produce a record.
That's correct, yes.
So the true question for us is whether the decision, as disclosed in your founding affidavit, was one which was subject to some form of review or another.
Indeed.
Do you say that Rule 53(1) applies to the review of a so-called common law review, which I understand is not a review concerned with the exercise of public power? It is usually concerned with the cases of domestic rules of clubs, which impose expressly or impliedly some duty to act fairly, for example, in regard to discipline.
Yes.
It's called a review. It's probably not a review in the modern constitutional sense, but either way, is that sort of review, does that fall within the scope of Rule 53(1)?
It does. the review that we sought to bring, Justice Rogers.
A common law,
Yes, it does.
common law properly called, you say it for, is there any authority that Rule 53(1) applies to such a review?
Well, in the context of this matter, Justice Rogers, it's the Bay Estates decision of the SCA.
Sorry, which one?
Bay Estates decision of the SCA, paragraphs 38 to 41 of that decision emphasize the fact that the reference generally to tribunals or associations is a distinction without difference, so to speak. The question is whether the decision is one that is made qua, and that's why I started my submissions on the basis of the equality, the equality issue. It's whether it's a decision that imports principles of fairness or that requires the consideration of principles of fairness. It's the decision itself, we have referred to it, Justice Rogers, in our heads of argument.
Just give me the reference again.
It's trustees for the time being of Legacy Body Corporate versus Bay Estates, 2022, Volume 1, SA 424 of the SCA.
Thank you.
Thank you, Justice Rogers.
Sorry, Mr. Chief. Just read that relevant paragraph. I read it quite some time. I just want to know, while you are on your feet, yes, how relevant it is.
Let me do that, Justice Matopo. So at paragraph 40, the SCA says the following. There, it was dealing with an apparent objection insofar as locus standi is concerned. But
just go slowly a bit.
I will do so, Justice Matopo. In my view, there is no merit to either of the two propositions. As to the first, it is mechanical and amounts to placing form over substance. The proposition was that you can't review these kinds of decisions decisions of estates generally in that matter. And then at paragraph 41, the court says, I tend now to consider the grounds on which a decision of a private body can be subjected to judicial review at common law. This would be the case where the decision maker failed to comply with the elementary principles of justice, such as, for example, where a tribunal misconceives the nature and ambit of its powers, or where it acts capriciously or malafide, or where its findings in the circumstances are so unfair that they cannot be explained unless it is presumed that the tribunal acted capriciously. That's the paragraph that I was referring to.
Where is that located? Is it located in the legality principle or the common law?
In common law. So the discussion here, Justice Matopo, was on the common law only. So it's located in the concept of the common, in the context of a common law review.
All right, thanks.
Thank you very much, Advocate Chikila.
Thank you, Deputy Chief Justice. God bless you.
Judgment is reserved in this matter, and the court adjourns.